for coming, everyone. As you know, I'm Paul Kurgis, the Dean of the Law School here, and I want to welcome you to the 2017 Blankenbaker Lecture. This series is supported by funds from the Blankenbaker Foundation, which was set up by the late Joseph Blankenbaker to support, in the words of the gift, increasing sensitivity to the responsibility for leadership and competence in the practice of law. So it's a lecture on professionalism, and we're very fortunate to have with us today Greg Murphy, a native of Anaconda and undergraduate of UM, who went on to Notre Dame for his law degree and then practiced for many years at the Billings law firm of Bolton Bellingham. Greg has made a national name for himself in the world of legal education and admissions to the bar. Among the many positions that he has held include chair of the Montana Board of Bar Examiners for many years, chair of the National Conference of Bar Examiners. He has chaired the Multi-State Bar Examination Committee of the NCBE and the Uniform Bar Examination Committee of the NCBE. This year, he is serving as chair of and this is a long organization, the Council of the ABA section of Legal Education and Admissions to the Bar. And for those of you who aren't familiar with the details of law school regulation, that is the entity that has primary oversight responsibility for law schools. The Council and its accreditation committee set the standards that govern law schools and also conduct the site visits as part of the reaccreditation process, so familiar to all of us from our own site visit earlier this month. And the report of that site visit committee will ultimately end up with the Council and its accreditation committee. Beyond his work on legal education and bar admissions, Greg is an accomplished attorney and mediator with a long history of practice that spans everything from bankruptcy and personal injury to Indian law. He's actually litigated cases in tribal courts as well as in the state and federal courts of Montana, and his wealth of experience has been recognized through many honors and awards, including serving as the distinguished practitioner in residence at the Cornell University Law School in 2015. So we couldn't have a better person to talk to us about professionalism than Greg Murphy. So please join me in welcoming Greg.
Well, thank you, Dean Kurgis, for that kind introduction. What's the old song? My father would have been proud to hear it. My mother would even have believed it. My high regard for Dean Kurgis began with our first contact. He reached out to me on an issue we both considered very important a few years ago. He was thoughtful, measured, courageous, loyal, savvy, and thoroughly professional in his approach. My admiration for him has only grown since. From afar, it looks like he's doing a bang-up job here at the Lewis School of Law. And in my view, you are very fortunate to have him at the helm of this great school. And then, of course, he invited me over to drop pearls of wisdom upon you. When I told my wife, Kate, about the invitation, she quipped, "They only ask old washed-up codgers to give these lectures, don't they?" Needless to say, one of the blessings of my life is that my Kate keeps me grounded. I have been intimidated by the task of preparing for this talk. I have humble roots. My paternal grandparents immigrated from Ireland to Anaconda at the turn of the 19th and 20th centuries. My grandfather worked for Marcus Daly's smelter. I'm not even sure that he knew how to read and write. My parents managed to work their way through the University of Montana during the Great Depression. They would be surprised that their son is standing before you today, although my mother did have an ambition for me to become a lawyer and did live to see me enter law school. I graduated from the University of Montana in 1976 with a Bachelor of Arts degree in history. What to do? Well, fulfill my mother's ambition and go to law school, of course. Moreover, that is what history majors who were not smart enough to become professors did in the mid-70s. I confess that I did not have an overwhelming ambition to do good, to promote justice, or to serve any particular cause. I was just looking for an honorable profession, and the law seemed as good as any. I took the LSAT in this building, where since prior iteration, applied to be admitted here, paid the fee. However, the records of this school will reveal that I was not accepted. Nevertheless, I found another place, and I left my sweetheart behind at the foot of Mount Sentinel. I didn't lose her, though. She married me a year and a half later and supported me in law school. While I had opportunities elsewhere after law school and my law clerkship on the West Coast, Kate was the driving force in our return to Montana, and I'm glad she was. She had become pregnant during my law clerkship, and she wanted to return to her hometown of Billings. I remembered my father's advice: if mom is happy, everyone is happy. If mom is unhappy, well, you know how that ends. Over the last 30 years, I've had the privilege to travel the length and breadth of this country, from St. John's in the Virgin Islands to Anchorage, and from Acadia National Park to Maine to Princeville on Kauai, and everywhere in between. I've met and worked with great lawyers from all regions, both in and outside the litigation context. Take it from me, this is the best place, and you are all fortunate to be here. For me, it has been a great life in Montana, a great life in the law. You who are students graduate and become members of the bar here in Big Sky Country, and you will join a bar with a long and storied history of outstanding and pioneering legal work. Your professors, I hope, have taught you about the many areas of the law where Montana and Montana lawyers have been at the leading edge. You will carry on that legacy, and I envy you, because indeed, I would like to do it all over again. The last time I spoke to a group of students and faculty was in March of 2010. Professor Martin Burke called me and said he wanted to nominate me for deanship here. I was initially reluctant to participate in the search. While I had labored in obscurity for years in the world of bar examining and law school accreditation, I had never actually worked in law school, and I had never been given a thought to leaving my firm of 30 years and the practice I enjoyed there. I demurred, but those of you who know Mark know how persuasive he can be, and so I agreed to participate. Then, to my surprise, I was named a finalist and was asked to campus. The dean search was a great experience for me. However, I would not have made a good dean, and the position was offered to a candidate who was far more qualified and savvy than I. But I credit that search for opening the door to thinking about making some changes in my day-to-day professional life. In October 2010, I told my firm I would be leaving at the end of 2011. Not that I was unhappy. I had happy clients and was making decent money. It was just that I had timed the market right and pulled everything out of the equities before the crash in 2008, and then got back in starting in March of 2009. Missed the 40% drop, participated in the bounce, and one's portfolio is held. That was the only time I have timed the market, and I will not do it again. Also, I was being asked to do more mediating, and I decided to devote more time to that work. I now mediate 4 to 6 civil controversies a month and take on pro bono cases. I continue to work with the National Conference of Bar Examiners and on the Council of the Section of Legal Education and Admissions to the Bar. The latter, as Dean Kurgas said, is the final authority on law school accreditation. Well, when Dean Kurgas called and asked me to give this talk, he mentioned my current role as chair of the Council of the Section. He may have been thinking I might talk about professionalism and legal education, or perhaps something related to my work with bar examining. I may have been able to put together something of interest along those lines, but Dean Kurgas gave me full rein, and so I will take a different path today. But if when we get to the question and answer period, you want to ask questions about the dreaded bar examination or what is going on nationally in legal education, please feel free to fire away. I may not know the answer, but I'll be sure to make something up. Well, now to the meat of things. The title of my talk today is, is this not working? If it cuts out and you can't hear me, somebody raise a hand.
You just do the microphone.
You could just do the.
I think there's another one, Greg. Let's just switch them out.
I'm hearing.
Yeah, it's got it. I believe there's another one. Let's switch these.
Yeah, it doesn't.
This is fine. This is work.
Yeah, that one does work. Is this on?
Okay. I'm used to lecturing in church, so maybe this will work. Well, now to the meat of things. That was a good point of departure. My talk today is the morality of the roles we play, living with ourselves and Kipling. As lawyers, we are called from time to time to engage in behavior in which we would not engage if we were not playing the lawyer role. How justifiable is that role playing, and what does it do to us? What are the tensions, and what do they cost us? How do we live with ourselves? These are serious questions. Each of us, no matter the stage of our career, should ponder them from time to time. Of the three historic learned professions, law, medicine, and the ministry, ours is by far the butt of the most jokes, and most of them pejorative. You may have read or heard of the research demonstrating that while lawyers are viewed by lay people with fear and mistrust, the vast majority of lawyers' clients like and respect their own lawyers. This is not just a function of the lawyer and the client being on the same team, so to speak. Clients are usually initially wary, but then when they see how their lawyers actually behave, most come to like and respect them. There are, of course, exceptions, clients with unreasonable expectations, clients whose lawyers dropped the ball or failed to keep them appropriately well informed. But in the main, clients tend to like their own lawyers. This should be good news to all of you. On the other hand, most lay people fear and distrust lawyers as a class. Our American society itself has a love-hate relationship with the legal profession. Lawyers have their hands on the levers of power, and people know it. Society knows it needs lawyers and generally understands our roles, but nevertheless wishes we were not necessary. Paragraph 3 of the preamble to our Montana Rules of Professional Conduct summarizes rather well the roles lawyers play. Quote, as advisor, a lawyer endeavors to provide a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. As advocate, a lawyer asserts the client's position under the rules of the adversary system. As a negotiator, a lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them. In addition to these representational functions, a lawyer may serve as a third-party neutral, a non-representational role helping the parties to resolve a dispute or other matter. Oh, the minefields in those words and those roles. We all have feet of clay, but the vast majority of us do indeed desire to do the right thing. That was his moral. But how do we know if we're doing the right thing when we are engaged in behavior that advances one person's interests, often at the expense of another? The most common method we lawyers use puts a great deal of emphasis on the role we play and examines how we ought to behave in the context of what is required by the role of the lawyer. This reasoning deflects criticism by justifying the behavior on the requirements of the role. What do I mean by this? Well, let's first examine this concept in a role outside law. Take the profession of arms. The occupation of the warrior presents the most striking example of justifying arguably morally objectionable conduct by looking to the role as the justification. My brother, graduated from West Point, was present when General Douglas MacArthur delivered his address accepting the Sylvanus Thayer Award. It was the famous general's farewell, and he discussed West Point's motto, duty, honor, country, and its meaning in the profession of arms. Here is a line from the general's speech on duty, honor, country. Quote, the code which these words perpetuates embraces the highest moral laws and will stand the test of any ethics or philosophies ever promulgated for the uplift of mankind. Its requirements are for the things that are right, and its restraints are from the things that are wrong. The soldier, above other men, is required to practice the greatest act of religious training, sacrifice. In battle and in the face of danger and death, he discloses those divine attributes to which his Maker gave him when he created man in his own image. No physical courage and no brute instinct can take the place of the divine help which alone can sustain him. However horrible the incidents of war may be, the soldier who is called upon to offer and to give his life for his country is the noblest development of mankind. Well, no one ever would accuse General MacArthur of not being grandiloquent. Well, that must be the quintessential example of the role justifying what, in other contexts, would be considered immoral behavior, the purposeful taking of human life. True enough, General MacArthur placed the killing in the context of a soldier's sacrifice of his own life. But there's no hiding the fact that the essential role of a warrior is, as George C. Scott said in the opening scene portraying George S. Patton's speech to the U.S. 6th Armored Division in World War II, quote, "No bastard ever won a war by dying for his country. He won it by making the other poor bastard die for his country." And so the role justifies the conduct. Let's look at the example of the general who's been given the objective of taking and holding a region. The science of war teaches him that with one plan, he might lose 5,000 of his troops and the enemy 10,000. With a different plan, he might lose 2,500 of his troops and the enemy 20,000. With the first plan, 15,000 troops are killed, and in the second, 22,500. But in the second, the general loses half as many men as half as many of his own troops as in the first. The role the general plays demands that the second plan be chosen, even though there will be a much greater loss of human life. His job, his role, is to accomplish the objective with the least loss of his own troops. But you say, we are not soldiers, we are lawyers. We are different. Are we? We are, in a way, warriors, at least when we play in our adversarial role, and we have similar tensions. Patrick O'Brien said of us, quote, "I do not say that all lawyers are bad, but I do maintain that the general tendency is bad. Standing up in a court for whichever side has paid you, affecting warmth and conviction, and doing everything you can to win the case, whatever your private opinion may be, will soon dull any fine sense of honor. The mercenary soldier is not a valued creature, but at least he risks his life, whereas these men merely risk their next fee." That, of course, is a pretty dim view of lawyers, and one with which I profoundly disagree. Nevertheless, candor requires us to admit that similar sentiments have been and will continue to be expressed by many others. And those sentiments are most are not expressed in general about those other learned professions, doctors and ministers. I hear those sentiments voiced in various ways by even my good friends who are not lawyers. To be sure, it is usually in the context of a joke, but we all know that in every joke is a kernel of truth, and the natural regard we have for the opinions of others affects us. Playing the role of the lawyer often does create tensions within. A lawyer defending a person charged with a crime may know with moral certainty that his client did the deed, yet the lawyer is expected to play her role. She may vigorously cross-examine a complaining witness with the objective of casting doubt on the witness's testimony in the hopes of obtaining an acquittal for her client. Presidential candidate Hillary Clinton portrayed herself as a lifelong advocate for women and girls. Yet, she defended Thomas Alfred Taylor, who was accused of raping then 12-year-old Kathy Shelton. Audio tapes later emerged of Secretary Clinton saying she believed her client was guilty and saying that his ability to pass a lie detector test, quote, "forever destroyed my faith in polygraphs," close quote. In any other context, Hillary Clinton's conduct might have been considered reprehensible. And indeed, during the last presidential campaign, it was argued that her conduct was just that. Among lawyers, though, we understood that her defense of Taylor was justified by the role. Secretary Clinton might have come to regret her work on the case because it might have cost her some votes. I suggest to you that she may have paid another price, inside her heart, conscience. Distasteful duties are not limited to defending those accused of crime, many of whom are in fact guilty. A few years ago, my partner and I were defending at trial Montana State University Bozeman and its College of Engineering against a Sex Discrimination and Equal Pay Act claim brought by Professor Alexandra Vinogradov, the only female full professor in the Department of Mechanical and Industrial Engineering. The opposition had retained Bernice Sandler as an expert witness to testify that, in her opinion, the dean of the college, the chair of the department, and the male faculty had discriminated against Dr. Vinogradov on the basis of her sex. The New York Times called Dr. Sandler the, quote, "godmother of Title IX," close quote. She has written extensively on the topic of sexual and peer harassment on campus and was the person who coined the terms gang rape and the chilly campus. At trial, she offered the opinion that Dr. Vinogradov's counsel knew she would. It fell to me to cross-examine Dr. Sandler, a person I had held in great respect because of her work, particularly in support of Title IX. I'll spare you the details of the cross-examination here unless you're interested during the question-answer period. Suffice it to say that it was a very successful cross-examination. Interviews of jurors afterwards revealed that her credibility in the jury's eyes, at least in that case, was destroyed. I admit that I did derive some professional satisfaction from a role well played using the skills I had been taught in law school and had honed over the years. On the other hand, I still look back with mixed feelings on that task I performed for the effect it must have had on Dr. Sandler. A 2016 study of 13,000 lawyers by Patrick Krill and Associates looked at the mental health challenges of the legal profession. The study found that lawyers report having the following: suicidal thoughts, 11.5%, anxiety, 19%, alcohol abuse, 21%, stress, 23%, depression, 28%. And these are among the highest in the professions. And that is just what lawyers voluntarily report. It does not account for those who repress the mental and emotional tensions and stresses and do not admit to them. True enough, there are many other possible causes for these kinds of mental health challenges. One's genes, a difficult domestic life, financial troubles, all can create mental health challenges. Nevertheless, I submit to you that playing the role and engaging in behavior on behalf of a client we would not do in another context can take its toll also. We need to be honest about this. As lawyers, we are often called upon to act largely with indifference to our clients' goals, so long as they are not illegal. Recall that line from our rules. Quote, as advisor, a lawyer endeavors to provide a client with informed understanding of the client's legal rights and obligations and explains their practical implications. And this is largely without the client's personal opinion. As counselors and advocates, we are sometimes called to exercise our independence and skills to achieve a result with which we might personally find unsavory. And so, a lawyer representing a landlord may be called upon to seek to evict a momentarily down and out tenant in favor of one who can certainly pay. Or how about the dilemma I faced early in my career when I was serving as a Chapter 7 bankruptcy trustee and discovered at a Section 321 hearing that a debtor had an unscheduled contested liability personal injury claim against the railroad, and the railroad was prepared to offer just enough in settlement to pay the creditors in full and have leaving a very small premium for the debtor, who would regrettably remain disabled. My primary role was to protect the creditor's interests. I had to take the offer, but I didn't like it. Sometimes the obligations of the rule can be muddied. How about the lawyer retained to represent the parents of an injured child who want the money to settle a claim paid to them as parents, but the lawyer, with good reason, believes the money would be quickly dissipated, and the lawyer knows that the court can order the purchase of an annuity for the child, which would far more likely result in conservation of the funds. What does the lawyer do in that role? Does it justify the action the lawyer takes? How about this one? A woman is driving her car on the highway well within the speed limit and otherwise perfectly reasonably when a car coming from the other direction and driven by an elderly man suddenly swerves into her lane of travel, striking her car head on and igniting a fire that consumes her 2 minor children riding with her. She and her ex-husband jointly make a claim against the elderly man, and his insurer promptly pays over the limits of the insurance. Then, her ex-husband sues her, alleging negligence. The suit is brought in a state that would lack personal jurisdiction over the woman, but has law favorable to the claim. Remember, one may waive personal jurisdiction defense by appearing without objecting. The state where the action occurred, and that clearly would have jurisdiction over the woman, because that's also where she lived, has law unfavorable to the claim. It still has intra-family tort immunity. The lawyer retained by the woman's insurer is instructed by the woman not to raise the lack of personal jurisdiction as a defense. Here, the lawyer is the agent for the client, but what about the language in the preamble to our rules of professional conduct? A lawyer shall always pursue the truth. The woman did not drive negligently. Yet it is evident she essentially wants to throw in the towel so that her own insurer will have to pay. What does the role of lawyer demand in that instance? And how does the lawyer live with himself or herself, whichever way he or she goes? The use of roles to justify behavior as moral is attractive because it provides a degree of moral simplification, telling us what to do. As an advocate, I establish facts that help my client's cause and downplay others. I work to defeat the other side's case, even if it is fully justified. I'll not forget the time I was faithfully and vigorously defending a client who was in a tough spot, and the federal judge turned to me and said, "You know, Greg, sometimes you read the complaint and it's true." I am a negotiator looking for a good deal for my client. Remember the words from our Code of Professional Conduct. As a negotiator, a lawyer seeks a result advantageous to the client but consistent with requirements of honest dealings with others. Does this obligate me to tell the other side that it's making a mistake? A mistake that could conceivably result in a malpractice claim against my friend and colleague, the lawyer on the other side negotiating the transaction? For example, am I required to call the attention of the landlord's lawyer that while in negotiations he had mentioned that his client desired a rent escalator in a long-term lease, but he neglected to put in an appropriate clause in the final draft of the lease he drafted, a lease which is otherwise completely consistent with the negotiations and satisfactory to my client. In this context, the other lawyer is not my adversary, and I'm required to deal honestly with him. Is it dishonest not to remind him of a negotiating point he made, but had not put in the draft of the lease he prepared? To raise the issue is not in my client's financial interests. What does the lawyer do? The psychological power of the role gives us comfort, security, and simplicity in a morally complex universe. But there are costs. A good friend of mine was asked to undertake representing on appeal a man convicted of 19 counts of federal crimes relating to pimping. My friend wrote a brilliant brief. He began by describing the horrors pimping visits upon women and then said, quote, "My client is a pimp." But he comes to this court armed with the U.S. Constitution. The Ninth Circuit reversed 18 counts, and on petition for rehearing as to the 19th count, reversed it too. The man walked, likely to go back to pimping. The role my friend played justified his advocacy for the pimp and gave him comfort, but my friend does not like to be reminded of his victory this day. The more striking examples I've given have arisen in practice of the criminal law, but the civil law practice poses its tensions too. The constraints of client confidentiality restrain. But I can say that in a surprising number of instances, my opponent has failed to discover, and not do any concealment on my part, a key fact that would have changed the outcome in my opponent's client's favor had it become known. The right question was simply not asked in a deposition. In other cases, the opposition failed to see what was there to see. Truck driving logs that simply could not be true, a false notarization on a document, the kinds of things that could kill the credibility of the case. I sat through depositions and trials with a poker face, wondering whether my colleague on the other side would discover the truth. I did nothing to prevent the discovery of the whole truth. I did nothing to suborn to perjury. But the role I played required that I not bring out the whole truth. I've long forgotten all the victories, but few of those instances where my opponent walked right by a critical fact. Let's go back to the rules of professional conduct. Paragraph 1, the very first paragraph of the rules says, "A lawyer shall always pursue the truth." How does that square with the other words from the preamble? As advocate, a lawyer asserts the client's position under the rules of the adversary system. The witness takes an oath to tell the truth, the whole truth, and nothing but the truth. But as a lawyer playing the role as advocate, I am not necessarily seeking the truth, at least the truth as most people would perceive it. This is what bothered Patrick O'Brien, and which bothers so many in society, and as you can see, has bothered me from time to time. Was I adhering to the admonition, a lawyer should always pursue the truth? I've successfully represented pro bono clients in avoiding paying debts they incurred, largely through an understanding of how to outmaneuver my opposition. For example, on 3 different occasions, I have been called upon to defend on a pro bono basis clients who were being sued by healthcare providers or by the debt collection agency to whom the claims had been assigned for unpaid medical bills. In each case, there was essentially no defense on the merits. I simply showed up at trial without my client next to me. In each case, the court asked if I was ready to proceed, and I said yes. My opponent had not subpoenaed my client. The court asked where my client was, and I said, "Your Honor, my client is present by my presence representing him." I gambled that my opponent would need my client's testimony for the case, and I was right. My opponent did not bring another witness competent to lay the foundation of documents, and I objected, and I pulled out the HIPAA regulations. I'll spare you the details. But in each case, my client prevailed for failure of proof. But who ultimately bore the cost for those unpaid medical services? You and every other person who pays for services or for the insurance covering the costs. In those cases where I played the role of lawyer was truth and justice served. Not pursuing the truth is not limited to actual trial work. Some of the finest legal work on behalf of clients I've done was in settling controversies early and before all the facts were disclosed. Now, I do not lie awake at night now fretting about these results. I understand the role I played, but I wonder, when I meet my maker, will I be asked? And will I say, but I was serving the greater good of peaceful resolutions of controversies? Will that response satisfy the Lord? Will it satisfy me? There are moral justifications for a lawyer's conduct other than playing the role. For example, in addition to society and the system having an interest in the lawyer playing the role, the agreement with the client demands it. The client has a legitimate and moral expectation that the lawyer will behave in the role as agreed. The lawyer has become the agent for the client and is bound to advance vigorously, we used to say zealously, the client's interests. We don't use the term zealously anymore because we deemed it too, shall we say, vigorous for the role. In any event, the client has a strong moral claim that his expectations of vigorous advocacy will be honored. Moreover, if the client cannot be assured that the lawyer will vigorously advocate in favor of the client, how can we expect the client to behave in the client's role? Be candid with the lawyer and let the lawyer bear the brunt of developing the case and making the argument. I've often observed that some lawyers appear particularly gifted in the adversary role in litigation because it seems they have internalized the role as a player in a game. Relatively early in my career, a large, complex, and important civil case came through the door, largely through an old law school contact of mine. I was the second chair of the case, which meant I was pulling the laboring oar and working up the case until trial. Lead counsel was Bill Bellingham, a senior partner in my firm who was universally regarded as a preeminent lawyer. Our client was in real trouble and knew it. Its parent company knew it. I knew it, and the pressure was on. And I was obviously sweating bullets handling a number of delicate and difficult issues. It showed in my demeanor around the office and in the hours I was devoting to the case. One day, Bill Bellingham walked into my office and said, "Look, Greg, it's only money, and it's not yours. And I'll tell you something else, Greg. There's only one thing worse than losing a trial. Do you know what that is?" "No, Bill, I don't." "What is the worst thing than losing a trial?" What said Bill, "Being afraid to try the case in the first place." Now, Bill had been in infantry and combat in Korea. He had witnessed death and plenty of it. Trials just did not worry him. He prepared for a trial like the best of them and performed brilliantly. But for him, it seemed to me, litigation was merely a game. The truth is that few of us are made of that stuff. Sometimes it's just plain tough to play the role, particularly when our client is in the wrong. It's okay to recognize this. We justify playing a role in our adversary system because we say, from the clash of professionals and from their presentation of evidence and arguments, the truth will emerge. Is that so? There was a time when trial was by torture. If the tortured managed to survive without confessing, then the truth of innocence was found, because surely the Lord would not permit a false confession. Or how about trial by combat? The Lord would surely ensure that the just champion would win. Well, we long ago gave up on these notions and replaced them with trials in courtrooms, or at least the threat of trials these days. Now, of course, thanks to liberal discovery rules, we do not have trials as originally conceived, searches for the truth. Rather, we have plays where the lawyers already know the essential story, and the lawyers are competing directors in the play with the judge and jury as the audience. The side that wins the greatest applause wins. As John Quincy Adams said, "He who tells the best story wins." We profess that this is the best way for the justice to emerge because a jury or judge, an independent judge or jury, will decide between the competing sides. But is that so? Does it always result in justice? We are enamored of the concept because that is what we have been taught and what we know. With lawyers playing our roles, justice will be served. Let me tell you another story on myself about how uncertain the civil justice system can be. A large hospital was having difficulty with the independent anesthesiologist practicing in its facility. Arguments over surgery scheduling, slow walking, or even refusing to do low-paying epidurals for women in labor. Arguments in front of patients, the list went on and on. The hospital staff protocols had proven very ineffective in bringing order to the chaos. So the hospital decided to close the department, grant an exclusive contract to a professional anesthesia company, which in turn offered employment positions to all the incumbent doctors. But they would no longer be independent, they would be employees subject to dismissal. Most of the doctors signed up. A few left town, and 2 brought antitrust claims. I was asked to defend the hospital in both cases. The first doctor included Sherman Act claims, among other theories of relief in his complaint, and so I removed the case to federal court where summary judgment was obtained. The Ninth Circuit affirmed in an unpublished decision, saying there was no economic merit to the claims. In those days, one was forbidden from citing Ninth Circuit unpublished decisions. So I could not tell the district judge about the Ninth Circuit rejecting the doctor's claim. The other doctor, the second doctor, did not bring federal antitrust claims, but rather only Montana antitrust claims, which are, by statute, supposed to be controlled by interpretations of federal antitrust law. The district judge, however, would not grant summary judgment, although the 2 cases were essentially factually indistinguishable for all antitrust purposes, and matter of fact, all the theories in the case. The jury in the second case returned an award of over $700,000, which treble became a judgment in excess of $2.1 million. I ask you, which was the truth? Which was the just result? Now, you might understandably take it that what I have said to be a criticism of the concept of playing the role within the rules as justifying behavior that in other contexts would be considered immoral. Yes, I put the issue on the table for you to consider and given a number of examples. This, however, begs the question, if not the role justifying the behavior, what then? Look the world over and see if you can find a better system. How about the European civil law system where the judges act as both interrogators and deciders? Anyone who's visited European courts or studied their system has witnessed their travails and their delays. And of course, the infamy of courts in communist countries is well deserved. The party line controls. Is there any confidence that tribal societies render better results? Perhaps our adversary system is like what Winston Churchill said on the floor of the House of Commons, of democracy. Democracy, he said, is the worst form of government, except for all others. Our profession and our legal system are part of the bedrock of our society and are indeed admired around the world, despite the criticism leveled here at home. The roles we play as lawyers do justify our conduct because the rule of law is essential to society, and we serve the larger societal interest by playing those roles. Moreover, for every instance in which I have felt the moral dilemma posed by the lawyer's role, I can say there were at least 20 when the rewards of playing the role were genuine. The satisfaction in playing a key role in resolving a dispute by peaceful means can be, and often is, rather profound. This can be true even when a case is lost. In the early 1980s, I tried a case for a new and large institutional client. I had warned the client of the risks and the likelihood of loss, and the trial was lost. Matter of fact, it was, I believe, the first lender liability loss in Montana. And my client, though, changed his practice as a result, and the client nevertheless very much appreciated the effort and performance I turned in and became one of my most faithful clients over the years. Indeed, I gained the impression that the client was as impressed with my work in that case, the case that was lost, as the cases in which the client prevailed. At the outset of my talk, I said I envy you for the students, for I would like to do it all over again. I meant it. Today I've described some challenges. I do not have the answers to the issues I've described. I do think it's worth an effort to be mindful of them, for if one ponders enough, one can usually find a way out of the thicket. In my title, I mentioned Kipling. How, you say, does he come into this? Well, I mentioned my mother earlier and her ambition. It's a little dry here. Rudyard Kipling was an author my mother liked, and she had memorized a poem and recited to me when I was young. Kipling, of course, was a famous journalist, poet, and individual in the late 19th and early 20th centuries, an Englishman, and he was the youngest winner of the Nobel Prize for Literature. His reputation has suffered in some quarters as cultural mores have changed. George Orwell himself called Kipling a prophet of British imperialism. Nevertheless, this poem has spoken to me down through the years of my professional life as a model for how to conduct myself as a lawyer. I hope Kipling will forgive the literary license my mother and I take, because I will be changing a word at the end of the poem, I'm sure you'll recognize it. The poem is called If. If you can keep your head when all about you are losing theirs and blaming it on you. If you can trust yourself when all men doubt you, but make allowance for their doubting too. If you can wait and not be tired by waiting, or being lied about, don't deal in lies. Or being hated, don't give way to hating. And yet don't look too good, nor talk too wise. If you can dream and not make dreams your master. If you can think and not make thoughts your aim. If you can meet with triumph and disaster, and treat those two impostors just the same. If you can bear to hear the truth you've spoken, twisted by knaves to make a trap for fools, or watch the things you gave your life to broken, and stoop and build them with worn out tools. If you can make one heap of all your winnings and risk it on a turn of pitch and toss, and lose and start again at your beginnings, and never breathe a word of your loss. If you can force your heart and nerve and sinew to serve your turn long after they are gone, and so hold on when there is nothing in you except the will which says to them, hold on. If you can talk with crowds and keep your virtue, or walk with kings, nor lose the common trudge. If neither foes nor loving friends can hurt you, if all men count with you, but none too much, if you can fill the unforgiving minute with 60 seconds worth of distance run, yours is the earth and everything that's in it, and which is more, you'll be a lawyer, my son. Thank you. I don't know how long did I go, Paul? I didn't.
We have it until 5. We got 15 minutes.
Oh, he said 45 minutes, so that was great. So, are there any questions or comments? I've got a very thick skin, so fire away. Faculty upset about the bar exam, what's happening in legal education, even the theme of my talk. Well, I can see. Yes.
Yeah, I wouldn't mind just hearing your general observations about changes in the legal profession, how they might affect changes in legal education. I'm thinking particularly about deregulation of the legal profession. So we've seen, I use that term loosely,
Yeah.
limited scope representation in Washington. We're starting to see sort of limited licenses for paralegals to do family law, and just sort of your thoughts of how you see us responding to access to justice crisis with deregulation or other.
Yeah, that is a topic of a week's lecture. But good questions. Yeah. Well, there's just no question that the profession is changing and will continue to change. And I don't think legal regulation is going to drive it. I think it's going to be driven by the market. People talk about artificial intelligence and we say, well, it's way off, but it's going to have a big impact. Dean Kurgis and I were talking about it a bit at lunch today, and he said, and I think he correctly observed, a lot of the functions of the emotional intelligence or judgment functions of lawyers, even some of them are going to be taken over by automation. But I think everyone agrees or believes now that the emotional intelligence, the judgment that lawyers bring, that a computer cannot bring, will be invaluable for a number of years. But who knows? I mean, look at what's happening with discovery. I went to one of my law school classmates, a fellow named Tom Fitzgerald, became managing partner Winston and Strong, which is a large Chicago loop firm, and I went to visit him August a year ago, 2 years ago. And I went into his office, and he gave me a tour around. And outside his office, there was a bank where the clerical help used to sit. There was no one there. And I said, well, Tom, tell me about this job. And he says, well, when I came into the job as managing partner in about 2005, it was great. I thought, this is easy. I can do this. And then what happened in 2008 and the years following that? He said that the biggest challenges facing big law are automation, computerization, and the lack of law in the world, rule of law in third world countries, which I thought was very interesting. This doesn't speak directly to the question, but I think the market is going to drive regulation rather than the other way around. Now, so far, the legal assistant program in Washington just hasn't taken off. It's not relieving the kind of pressure. It's not doing what we want to do. I think there may be an answer somewhere along the way of going the way medicine has a certain degree with physician assistants. I mean, medicine is a way, some like law. It's a seamless web. But there are things that less skilled people or less educated people can do. I mean, I think it's possible, for example, that full-blown lawyers it's not necessary to have them do a Chapter 7 bankruptcy petition. But I have to say, there are issues that come up that need a lawyer's attention and maybe specialization. And right now we give these general licenses, right? But we all know that lawyers specialize many places they specialize not long after leaving law school. And I'm thinking maybe that's the way we ought to go. But I think that the demands of the clients are going to just drive the whole system. And, the AALS is undertaking a study on why the market in law school applicants has dropped so dramatically and not bounced back like we thought. Right? In most recessions, that was good for law schools because people went to law school through the recession. That didn't happen this time, and it stayed down. We have 40% of the applicant pool has dropped 40% since 2010. We haven't had this few number of law schools since mid-19s. Excuse me, this absolute number of law applicants since the mid-70s, and we have about 50 more accredited law schools. So it's a pressure. I don't think regulation is the answer. I think deregulation is probably going to take place no matter what we do. And it's for us, I think, the lawyers who will, I think, in the end control, because we control, I mean, justices of the Supreme Courts control the profession around the country, and they're ultimately going to make the decisions to the degree of which there's regulation. I'm not sure if that answers your question, but the other problem we have access to justice is what the cost of law school now. The average debt last year, average debt was $120,000 for students. Well, if you think of how tuition discounting takes place now, with the bottom half paying for the upper half in many schools, you realize that average is deceiving. The people most at risk of not becoming admitted to the bar are the ones for those who are going to, likely. Law school faculty nationally increased 37% in number between 2000 and 2010. There's retrenchment going on as necessary. I'm actually an optimist. I think that law schools continue to do a really fine job of training people. I think it's a bit of it's not a bit of it's a real challenge to say we're going to have people ready to practice law when they hit the ground running. I know this school has it in its wheelhouse, preparing people through clinical experiences and experiential learning, which I think is perfectly appropriate for Montana. But, most places, the unwritten bargain for law schools and legal profession, ever since Christopher Columbus Langdell at Harvard developed the case method system teaching laws of science, the bargain was, the law schools will teach people how to think like lawyers and how to analyze and doctrine, and the profession will train them up. Lawyers would learn actually how to practice law as they had always learned to practice law under the tutelage somehow of another lawyer or watching other lawyers in action. I really don't think that's going to change very much as we make efforts for clinical education. I don't mean to criticize my friends in clinical education. I think that's just a fact. It takes a long time to know how to practice law. What's that old saw? You want a young surgeon and an old lawyer. There's a lot of truth in that. Yes.
Yesterday, speaking a little bit about court-ordered mediation, how that creates an imbalance when in determining the facts, as opposed to putting it before a jury.
Yeah.
So my question is, because so few cases go before a jury, so that true exploration of the facts and the truth becomes lost when you have an imbalance of power in mediation, where you have someone who's paid as like maybe an insurance company versus a terrified plaintiff.
Oh.
Understand the system or things like that, where it becomes an imbalance in the ability.
Well, I'm going to push back a little bit on the premise of your question, because I am doing a lot of meeting, and Dean Kruger says, I wish we had more trials. And I think I do, because I wish we had more trials too, because we'd have a better understanding of what's going to happen, right? This from experience. But I think mediation has been a real boon to resolving civil disputes. And I've mediated cases early, I mediated them under court order, and I mediated when the parties wanted to do it. There certainly are differences in all three kinds. But I haven't seen the disparity of power that you mentioned, at least in Montana, where my mediation practice is conducting. In fact, you mentioned the phrase plaintiff's lawyer, plaintiff. I always tell the clients, I'm the mediator here. I'm to help you try to find middle ground, or if not a middle ground, a ground upon which this case can be resolved. But you hired a lawyer here, and the lawyer's your lawyer. Listen to your lawyer's advice. So I rely a great deal upon counsel to advise their client. Frankly, I find that sometimes I end up being the lawyer in terms of telling the client the truth about the case. Sometimes, I've gone into some mediations where, after looking at everything, and I get pretty good presentations from people. I don't require a particular format about the case, the key facts, and the law. And my experience is that regrettably, some lawyers they need me to affirm what they've been telling the client, right? And that seems to have a very powerful impact. And I think it's been rare that I've staked out a position on how I think things ought to be resolved where the lawyers haven't agreed. Now there's some cases that I've tried that just happens, but I don't see disparity of power as an issue in my experience. I haven't observed it then. But on the other hand, I deal with mostly complex commercial matters. I haven't done a lot of personal injury mediation, which is, could be a different kettle of fish in terms of that reaction. But even there, when I was actually practicing as a litigator and had some personal injury cases, I used to represent the oral surgeons in the state. They had formerly had a commercial carrier that they were very upset with because they were selling all these claims out, and so they formed their captive carrier. It's called OMSNIC, Oral Maxillofacial Surgeons National Insurance Company. It was a good company. I mean, they settled cases when there was a mistake. Soon they found out they were willing to litigate cases and try them if they didn't. And I remember a mediation where my client had committed malpractice, and there just wasn't any real doubt about that. So the mediation was basically about how much the client was going to get, either trial or through the mediation. And Tracy Axelberg was the mediator, and we just couldn't get it done because the general damages that the other side wanted, I don't know whether it was the lawyer or the client or some combination of both of them, were just too high. And Tracy told me, interesting enough, that he had kept track. Tracy does a lot of mediations out and over on this side, as you probably all know. He kept track of all the cases that personal injury cases that he was unable to get resolved in mediation to see what happened at trial, if they went to trial. And he says, and not one of them did the general damages award exceed that which had been on the table in mediation, which I thought was very fascinating. And I thought, well, where's the power balance there, right? So, yes.
I really enjoyed your talk. However, I was most intrigued by your observation, the questioning about economic and market forces driving regulation.
Yeah.
And of course, it's obvious that those will impact attorneys, but I'm really curious about what you think the future looks like for paralegals. We had a guest speaker last year, John Morgan, a Florida attorney plaintiff's attorney who created this vast regional practice making gazillions of dollars. And it seems like he did it by a combination of a sophisticated advertising scheme in combination with really widely cross-utilizing paralegals at a level that maybe hasn't been done before. And it also sounds like states like Washington are considering licensing maybe smaller amounts of duties that paralegals can have and so forth. I'm just curious what you see as the future for paralegals taking more work.
Well, I haven't given much thought to it. I think that maybe that's a corollary of what we're talking about, where having people who are less skilled and less educated. I wouldn't say less skilled because there are plenty of paralegals I saw were more skilled than the lawyers they're working for. But I think there's room for them in certain kinds of cases, and let's face it. I mean, much of what used to be the bread and butter of lawyers, particularly lawyers in Montana, where we possess the knowledge. We possess the knowledge of how to do a corporate formation, partnership, or whatever, or draft a lease or something like that. It's now online. Clients know that, and so that bread and butter is just disappearing. And so lawyers are going to be involved more in when there's a contest. It seems to me that there might be room for paralegals doing some counseling on terms of those simpler things where people, but it's the cost is driving it. I mean, people they don't have the money to pay for it. I mean, frankly, I often thought, gosh, if I got sued and I didn't have insurance, where would I be? I represented one oral surgeon who had, oral surgeon. He was an endodontist and was accused of malpractice. And he was sued, and an oral surgeon was sued. That's how I ended up picking up oral surgeons of this case. But, my client really didn't, had pretty good defenses on liability, and but he wasn't insured. And I could settle the claim for less than what it was going to cost him to litigate the claim. And I often wonder if there isn't some room for mediation even in those kinds of cases. I certainly don't. I question when you've got clear liability, there isn't any doubt, whether lawyers ought to take a contingency fee on those kinds of cases. But, then I hear the justification, yes, but if we don't take a contingency fee on these, then how do we take those ones that are, are iffy? But that's shifting the moral obligation burden, from one client to another, which I have a problem with. Certainly the clients don't look at it that way. I'm not sure if I answered your question, but I as long as lawyers control it, I have a hard time seeing them turning a lot over to voluntarily over to paralegals. And as I say, I don't think that I've been told, and I read, the practice in Washington with limited licensed practitioners has not taken off. Any other questions? Dean Kurgis?
Well, we've only got a couple of minutes, but I'm curious, you obviously have had a long practice in Montana, but you've also seen the legal profession all over the United States in your roles at the national level. And I'm wondering what you see as the role of the small state lawyer, as we see the legal market separating into a handful of very large firms and then more and more lawyers in solo or small practices.
Yeah.
What would be the effect on lawyers in a state like this one?
Well, we're kind of behind the national trend, whatever it is. But I just don't see our population ballooning to the size where it's going to change the nature of practice law very much in Montana. I mean, we may see more associations like, is it AVO, or some of those associations like that. But I'm not sure that and I've got a friend who practices one of those groups. It doesn't make much difference. And I just think the nature of the population here, our economy, I remember reading, this is probably 10 years ago, but I doubt it's changed much. It was an article in Economist magazine that said it was on the new American ghetto, the Northern Great Plains. And 7 out of the 10 poorest counties in the country, as measured by per capita income, were in Montana. Now, many of them were where Indian reservations reside, but it tells you, and what are we in terms of per capita income? We're down below number 45, I believe. That's just not going to change the very nature of what we do here. We're still going to be dominated, I think, by small practitioners, many of them hoping for a good plaintiff's case to come in the door. A few larger firms that handle the defense of larger institutional clients, and insurance companies. But insurers are changing the practice. I mean, I remember a time when insurers would try cases. Now they just assume settle as quickly as possible. They just learned that the cost of litigating is more than over the long haul. There are exceptions to this rule. I mean, Otis Elevator, for example, they will not settle a case. If you want to take on a case against Otis Elevator, you'll be trying the case. I used to do work from State Farm Fire and Casualty came to me in the mid-90s, and they wanted me to handle all their large loss cases in eastern Montana. Would I do it? And it was a cut of my rate, but it was more than they're paying so I took it on. It was fire and casualty, not auto. I wasn't interested in the auto. Fire and casualty is more interesting. I got more interesting cases. They were a good company. I mean, if it was a case we wanted to settle, fine. But if it was a case we wanted to try, I don't know what their practice is now, but at the time they'd say, fine, we'll try it, waive the limits, and go try it. They would protect their insured up to the hilt, which is a great circumstance. I mean, if you're a trial lawyer and your client is being sued and suddenly you find out that you've got a company that has more money than God standing there, it's waived the limits, well, what could go wrong, right?
Okay.